is the ability of the seller to cancel an installment sale agreement. Very difficult because it's registered at the deeds office and there's prescribed notice periods. Now, if the purchaser does in fact breach the installment sale agreement and the seller does in fact have a valid claim to cancel the installment sale agreement, and then it transpires that the purchaser has spent money on the property and now claims that they want a refund of the money that they spent from the seller, that's a different conversation, right? Because at least there the cancellation and termination was valid. And to answer that question, does the purchaser have a claim? Now, first thing you need to look at is the terms of the agreement. Most agreements have specific provisions to say that nothing should be done to the property unless the seller has consented to it. And that's a very important one. If you intend to do renovations to a property or improvements to a property, please be very specific about what you intend to do, how you intend to do it, and the consequences. That if something happens to the agreement, how are you going to recover, or what is the recourse? Because under most circumstances, if the seller has not consented to improvements of the property, the seller need not pay for such improvements. Most under our common law, if anything done to the property, for example, repairs, were necessary and they were done and the seller was enriched by these repairs, there you might have a claim. As a purchaser, you might have a claim for those repairs because they were necessary. They had to be done. Otherwise, the property was going to collapse. It was something big. But if it's luxurious improvements where, yes, it increases the value of the property, there are circumstances, especially if the agreements say that the person was not allowed to do it, they will not be able to reclaim that money back. So just be very, very careful. This falls within our the scope of our law in respect of undue enrichment. So there's many different things to consider. If you do something in a certain way, you can claim these costs. But if you do it in another way without consent, you're not allowed to. If you do it with consent, you might be able to. So there's different ways of approaching it. But rule of thumb is the contracts do not allow for a person, especially as a tenant, because think about it, in the interim, it'll probably end up looking like a lease agreement. And if a tenant goes out and tries to do massive improvements to the property, they're not allowed to do this because the lease doesn't allow them to do it. And a tenant will not be able to claim from the landlord the value of those improvements that the landlord never asked the tenant to attend to. Repairs, necessary repairs, very, very different story.
Perfect. Thank you so much, Bruno.